So we go on to the modern approach of proprietary estoppel. Now, these set of principles were clearly applied in the case of Taylor Fashions. All right. The Taylor Fashions case went away from the Wilmot criteria, the five probandhas we mentioned earlier. They did not, in the case of Taylor Fashions, they did not slavishly want to adhere to those old principles, because it was considered that these old principles laid down by the case of Wilmot versus Barber were, quite frankly, a little bit stringent, and it was not very easy to be established. That is why, in the case of Taylor Fashions, they moved on to applying a newer, much more refined set of principles. And those are the elements that are now utilized by us. So in order for a successful claim of estoppel, we must establish these four principles. Representation or assurance, same understanding is there for a representation or an assurance. And then the second element is reliance. Third is detriment, and finally unconscionability. So these four requirements are what we consider as being the four main elements that must be established in order to successfully raise an estoppel. All right. So early on, the courts thought these four principles were unique and distinct from each other. So in raising an estoppel, the consideration was to see whether each element was established. All right, Vicky? However, later on, in the cases such as Gillette versus Holt and Jennings versus Rice, these type of cases brought out the notion that these elements don't stand alone. These four elements are very much linked together, and one depends on the other being there. In order for an estoppel to arise, there should be a representation. That representation must be considered and relied upon. That reliance is what causes a detriment to be suffered by an individual. And if there is a representation, if there is reliance and detriment, there is a possibility that estoppel would arise, but only if it was unconscionable. So as you can see, these are very much interlinked. So let's assume that Vicky gave me a representation as to the fact that she would transfer the title of a certain property to me. Now, we've known each other for quite some time. We were good friends, and that assurance meant something to me. Because of that promise or that assurance or that representation that was made by Vicky to me, I gave up my own property. I sold off my house. Maybe it was not a good time to sell off my property, but I still, for a lower market value, I sold it off. And because of your representation, I gave up my own property, lower price, and I gave you an advance payment also. Now, why did I do all of these actions? It was because I relied on your assurance. And if you decide, Vicky, not to transfer the property to me, all of these actions would have caused me, all of these actions that I have done through the reliance to your assurance or representation made would definitely cause detriment to me. But just because there's a representation, if there's an reliance and detriment, doesn't mean that an estoppel can arise. It would arise only if all these three elements acting together would render it unconscionable for you to go back on your promise. Erica, is that clear for you as well?
Yes.
Perfect. Vicky, I assume you also are okay? Yes? Perfect. Right. So these elements are the most vital in establishing an estoppel. So an assurance is quite simply a representation made by the landowner himself. It can be expressly given, it can be implied by conduct. When it comes expressly, it can be through an oral representation. A representation can even be through writing. An oral representation or a representation in writing is very easy to establish in a court of law because it has clear-cut evidence. But an assurance by conduct is not that easy. In that scenario, however, there has to be sufficient evidence to prove that such conduct by the landowner would imply such assurance. That is very important for us to understand. Now, when it comes to the assurance or the representation, early on the courts brought in the understanding that it has to be a very specific representation or an assurance made related to a property interest, a proprietary right or an interest. So that assurance or that representation has to be very specific. If I tell you that I am going to give you my freehold title, that is a very specific interest that I have represented you upon. But later on, as law emerged, changed, adapted, the case of Thorner versus Major brought out the notion that in order for a certain statement to qualify as an assurance, it need not be very specific. As long as it's certain enough, that would suffice to qualify as an easement. However, as long as it is related to a proprietary right, a mere personal statement, a mere personal right would not qualify as being a valid assurance. Then we move on to reliance. Reliance, like I told you, reliance is the change that occurs due to the representation of the claimant. I gave up my own property for a lesser value than it actually is. Maybe your property was a couple of cities far away from mine. I might have given up my job. If I had kids, I might have had to take my kids away from their new current school and brought them to a new school. All of these things, all of these changes, selling my own property, changing my job, taking my children away from their current school to find new schools, all of these things were done because of the assurance. Those were done in reliance of that assurance. So this is the change that I brought upon myself in order to facilitate the assurance. Assurance on that statement or a reliance on that assurance or representation is what must cause detriment. All right. Reliance is what links an assurance or a representation with detriment that is suffered. Sometimes detriment can suffer regardless. If that detriment cannot be linked to the assurance by reliance, then definitely an estoppel will not arise. So how intertwined these principles are has to be understood. Now, sometimes things that individuals do from the kindness of their heart can be said to be done without any reliance on an assurance. But still detriment can be suffered, but the reliance factor is confusing there. Why? Well, let's say there's an old lady who does not have any other next of kin. She has extensive estate, and now let's take the best case, Jennings versus Rice. I assume the case facts are as I remember for Jennings versus Rice. Yes. So there was this old lady who had large extensive estate, and there was her gardener. Her gardener initially, though, carried out work in the garden. As the old lady became a little bit ill, the gardener took on certain duties beyond the scope of his job. He took care of her. He ensured that she was comfortable, and he took care of her needs, day-to-day needs, because he took the role of a carer as well. And when that happened, this old lady made certain assurances that this gardener was now doing certain things out of the way, and because of that, assurances were given by him that he would acquire certain interest over land when the old lady passes on. So in that sense, when the old lady died and did not leave anything in her will to this gardener, the gardener wanted to raise an estoppel. Now, in this case of Jennings versus Rice, there was clear understanding that all the actions done by the gardener was in reliance to the assurances made. There was no issue there. But what if this individual, the gardener, let's see, through kindness of heart, did all other things for the old lady? Then obviously he would suffer detriment, no? Certain expenditure incurred by him, the time he has spent, the detriment will be there. But what if he did all of this with the kindness of his heart? That means regardless of whatever said by the old lady, he would have still done it out of the kindness of his heart. So if there was a representation made or not, still it would amount to a detriment. But is there reliance on that assurance? Definitely not. So this was an issue that the courts had to resolve, because now if the courts gave out the idea that only selfish, well, not selfish only, but things done with an ulterior intent are only to be rewarded, would be something that would be very immoral. Would you agree, Vicky? So there was an issue. In cases such as Otti versus Grandi, Tan versus Ho, these cases, the claimants did certain things that amounted to detriment out of the kindness of their heart. And courts, when they brought a claim of estoppel, The courts had a little bit of a hard time establishing reliance. Why? Because detriment would have been suffered regardless of the assurance. So there was an issue with the reliance type in cases such as Otti versus Grundy and Chan versus Ho, unlike Jennings versus Rice. However, the court said, still, even though those actions were done with the kindness of the heart, the courts imputed reliance, is stating that these type of actions, even though done through the kindness of heart, are done with at least a simple consideration of the assurance by the landowner. So a little bit of a different idea for the concept of reliance from the general idea that we just learned a few seconds ago. All right.